recognize the Honorable Nisay to manifest his position with respect to the sufficiency of substance of the De Jesus complaint.
Good morning, Madam Chair, colleagues, and all esteemed guests. The De Jesus impeachment complaint being sufficient in form, it may now be examined for its substantive sufficiency bago ito magpatuloy sa mga susunod pang stage ng impeachment proceedings. Kung susuriin, ang impeachment complaint ay nakabase sa tatlong ultimate grounds of impeachment. 1. Graft and corruption. 2. Culpable violation of the Constitution. And 3. Betrayal of public trust. Dinipay na ng ating Korte Suprema sa kasong People versus Palasige, citing Martel versus People, ang mga salitang graft at corruption. Base dito, graft is the fraudulent obtaining of public money unlawfully by the corruption of public officers. It also refers to advantage or personal gain received because of the peculiar position of superior influence of one holding a position of trust and confidence without rendering compensatory services or dishonesty transaction in relation to public or official acts. Sa kabilang banda naman, dinipay nito ang corruption in its fundamental sense as the act of an official fiduciary person who unlawfully and wrongfully uses his station or charter to procure some benefit for himself or for another person. Contrary to duty of the rights of others, it pertains to an act done with an intent to give some advantage inconsistent with official duty and the rights of others. Kasama sa De Jesus complaint ang aligasyon na ang totoong layunin ng pagbuo ng ICI ay para protektahan ang mga taong punot dulo ng korupsyon sa bansa. Kapansin-pansin nga naman na walang nangyaring pag-imbestiga ang ICI sa mga pangalang ikinanta ng taong kanilang tinutugis ngayon at napabalitang nasa Portugal at Sweden. Dagdag pa, bigla na lamang natapos umano ang layunin ng ICI pagkatapos lumutang ang pangalan ng Pangulo na siya umano ang may utos ng lahat. Partikular na ang pag-deliver sa kanya ng mga quote-unquote basura. Hindi biro ang mga bilyones na laman ng mga maleta na kung tawagin nila ay basura. Ang mga basurang ito ay dugot pawis ng mga mamayang Pilipino na tapat na nagbabayad ng buwis ng buong tiwalang ang perang ito ay gagamitin para sa ikauunlad ng lahat. Ang basura pong ito ay kayang-kayang magpagaan at magsalba ng buhay ng mga Pilipino. Ang mga basura pong ito ay kayang makapagpakain, makapagpaaral at makapagpa-ospital at makapagbigay ng maayos na tirahan sa bawat pamilyang mas nangangailangan. Ngunit ang basurang ito sa kasamaang palad ay di umano ginamit para sa pangsariling interes ng iilang tao lamang at kasama na diyan di umano ang ating Pangulo. Pangalawa, culpable violation of the Constitution. Binanggit na ito ni kagalang-galang na si Father Bernas sa kanyang komentary na The 1987 Constitution of the Republic of the Philippines. A commentary na the culpable violation of the Constitution must be understood to mean willful and intentional violation of the Constitution and not violations committed unintentionally or involuntarily, or in good faith or through an honest mistake of judgment. Kasama sa complaint ang aligasyon na nagkaroon ng Pangulo ng pag-bypass sa ating justice system ng kanyang hinayaang maipadala ang dating Pangulong Presidente sa ibang jurisdiksyon, partikular na sa International Criminal Court para doon litisin. Nangyari ito sa pamamagitan ng pagkilos ng PNP na alam nating lahat ay sumusunod at nasa ilalim ng direktiba ng ating Pangulo. Pangatlo, betrayal of public trust. Sa kasong Emilio Gonzales versus Office of the President acting through the represented by Executive Secretary Paquito N. Ochoa Jr. et al., sinabi ng ating Korte Suprema na the Constitutional Commission eventually found it reasonably acceptable for the phrase betrayal of public trust to refer to acts which are just short of being criminal but constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary powers. In other words, acts that should constitute betrayal of public trust as to warrant removal from office may be less than criminal but must be attended by bad faith and of such gravity, seriousness as the other ground for impeachment. Malinaw na papasok dito ang aligasyon ukol sa failure ng Pangulo na ibito ang unprogrammed appropriations at ilang special provisions nito sa ating mga national budgets. Naiintindihan din natin na walang legal duty ang Pangulo na magbito ng items dahil discretionary ito sa ating saligang batas. Ngunit naniniwala tayo na dapat kalaki pa rin ang moral aspect sa issue na ito. Hindi ba naging prioridad at magiging prioridad ng Pangulo ang usapin sa kalusugan at kakulangan dito? Hanggang kailan magiging one hospital away from poverty ang mga Pilipino? Tama naman na ito ay short of being criminal, but such failure to act already constitutes a gross faithlessness against trust, a gross exercise of discretionary powers. Kahit Korte Suprema rin ay dineklara ng unconstitutional ang pag-transfer ng pondo mula sa PhilHealth na nilipat sa National Treasury. At bilang isang health advocate, nabahala tayo sa naging issue na ito, particular sa 60 billion pesos mula sa 2024 PhilHealth Reserve Fund. Ang pondong ito ay nararapat lamang sa pagpapalakas ng ating universal healthcare system at magamit ito ng mga Pilipinong higit na nangangailangan. Ang pondong ito ay nararapat lamang na matulungan ang mga pasyenteng hirap sa bayarin, maisaayos ang mga hospital at health units nakakulang sa kagamitan at pasilidad, at mapataas ang benepisyo ng ating mga healthcare workers. Naniniwala tayo na kung hindi na mauulit ang katulad na problema, siguradong panalo at makikinabang at mamamayang Pilipino. Madam Chair, nahiyag din sa complaint ang revelasyon ni Senator Amy Marcos tungkol sa paggamit ng ipinagbabawal na droga ng Pangulo. At ang katotohanan na walang naging malinaw at direktang naging sagot dito ang Pangulo. Batid kong umaasa ang sambayan ng Pilipino na ang namumuno sa kanila ay isang taong intelektual at hindi impluensyado ng droga o anumang harmful at illegal substance. Again, inaction of the President with regard to these allegations may be considered as gross faithlessness against public trust. Tandaan natin, walang gagawa ng mali ang ipapakita o sasabihin sa lahat na siya ay gumagawa ng mali. Masigit lalo na walang taong nasa mataas na posisyon ang personal na gagawa mismo ng mali. Kaya rin sa ating justice system, particular sa Revised Penal Code of the Philippines, may tinatawag na principle by direct inducement. Kung susuriing mabuti, ang mga aligasyon na ito ay tumutumbok sa isang conclusion, that the President most likely is not anymore fit to govern. Malayo pa ang proseso, pero malayo na ang narating ng hangarin na magkaroon ng mas maayos na pundasyon ng ating pamahalaan. Madam Chair, in view of the foregoing, I respectfully submit that the impeachment complaint be deemed sufficient in substance and that it accordingly be allowed to proceed to the next stage of the proceedings. Magandang araw po muli sa ating lahat.
Thank you, Honorable Nisay. That completes and concludes his manifestation of position in as far as sufficiency in substance of De Jesus' complaint is concerned. We understand that at the end of our deliberation on the sufficiency on substance with respect to this impeachment complaint of Attorney De Jesus, we will be voting on the entirety of the impeachment complaint. Nonetheless, for purposes of clarity of our proceeding, considering that there are 5 offenses alleged, anchored on 3 grounds, we will be eliciting the comments, opinions, and questions from the members of the committee in accordance to the grounds alleged in the impeachment complaint. Let the chair reiterate that while we discuss it on the basis of grounds at the end of our deliberation, we will be voting on the sufficiency in substance on the entirety of the impeachment complaint. At this point, we will be eliciting the comments, positions, or even questions of the members of the Justice Committee with respect to the sufficiency in substance of De Jesus' complaint, which position was manifested already by our endorser, the Honorable Nisay. We will begin with the first offense. Let me read. Respondent ordered and enabled the kidnapping and surrender of former President Rodrigo Roa Duterte to the ICC. This is the offense charge, and the same is anchored either any or all of the following grounds: culpable violation of the Constitution or betrayal of public trust. Members who wish to manifest.
Madam Chair,
The Honorable Ridon is recognized.
I think prior to even talking about anything else, I think we need to state for the record that what is important in the submissions would be two things, no? Personal knowledge or authentic records that had been submitted as part of the impeachment complaint. For the first impeachment complaint, may we know from the Secretariat on what the annexes, on which annexes had been submitted as authentic records, Madam Chair?
May we ask the endorser if he is willing to answer the question instead of the Secretariat answering the question? The Honorable Ridon is asking on the annexes attached to the complaint in support of the offense of kidnapping and surrender of the former president to the ICC.
To be clear, Madam Chair, this is not just a question on the specific ground, but as a general question on all of the submissions, because you have annexes here, but we would want to know whether what had been submitted are authentic records, particularly whether the submissions are certified through copies of particular official documents. Madam Chair.
The chair stands corrected. The question pertains to the entirety of the impeachment complaint.
And to explain why we are asking this, in previous impeachment complaints, the complaints had been rejected by the House Committee on the basis of that these impeachment complaints had not been submitted because on the basis of personal knowledge or because of submission of authentic records. So I think the same standard
Point of order,
should apply
Madam Chair.
to.
Point of order.
The Honorable Ilaga is recognized with the indulgence of the Honorable Ridon.
Representative Ko.
Honorable Ko.
Okay. Thank you, Madam Chair. Madam Chair, to my understanding, for now, we are in the stage of assessing the sufficiency of substance of the impeachment complaints. We are observing Rule 3, Section 5 of the 20th Congress Rules of Procedure in Impeachment Proceedings, which provide the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. So for the purposes of this exercise, Madam Chair, what we need to do is to determine whether in the complaint there is a recital of facts which, one, provides the jurisdiction of this committee, and number two, whether it constitutes the offense charged. So we do not yet need to enter into a discussion whether the recital of facts actually is based on personal knowledge or based on authentic records. That can come later, Madam Chair, in the hearing proper when the committee has already determined whether there is sufficiency in substance, whether the facts alleged in the complaint constitute the offenses that are being charged, which in the case of Honorable Nisay would be corruption, betrayal of public trust, etc.
Any member who wishes to
Madam Chair.
respond? The Honorable Tino is recognized.
Thank you, Madam Chair. In addition to the point made by Representative Ko, I would like to point out that the matters raised by the Honorable Ridon have already been settled in yesterday's proceedings, namely the determination of sufficiency in form, where precisely the committee found that it was indeed sufficient in form, meaning that the complaints, both complaints were verified complaints based on personal knowledge and or authentic records. So that point has already been settled as far as the rules provide. No? And any further discussion on those is out of order at this stage.
The Honorable Chua is raising his hand.
Madam Chair, hindi po ako I will not dispute kung ano man po yung kanilang sinasabi. Kasi kanina po binabasa ko lamang po itong mga... Dito pa lang po tayo sa una, tama po ba? Dito po sa kidnapping, tama po ba?
With due respect, the Honorable Chua, there is a pending query on the validity of the question of the Honorable Ridon with respect to the attachments to the impeachment complaint of De Jesus. This is being disputed by the Honorable Ko and the Honorable Tino, as they are claiming that this should be asked after the determination of sufficiency in substance, if I stated it correctly. So let us dispose first this matter before we proceed to other issue. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. As already been pointed out repeatedly, narration of facts, which means that it excludes bare allegations. This is an impeachment complaint, and we are at the stage of determining sufficiency in substance, which should contain narration of facts. The definition of facts, it must be distinguished from bare allegations, because bare allegations are not evidence. We should concentrate on whether or not, yes, we have to deal on the four corners of the complaint, but we should see if there are narration of facts which are not bare allegations which can possibly lead to a proof that there is constitutional violation which is an impeachable offense. Madam Chair, Your Honor. So I do not agree that just allegations will be considered to determine sufficiency in substance. I
Madam
respectfully submit.
Madam Chair.
The Honorable SDML is raising his hand. SDML Lawrence Defensor is recognized.
Thank you, Madam Chair. If we look at the heading of Section 5 of our Rules of Impeachment, it says, determination of sufficiency of substance. It's not acceptance of a recital. The word determination, it bears emphasizing that it is upon the responsibility of this committee not simply to accept a recital in an impeachment complaint. We have the duty to determine it with diligence. And it is not acceptance merely of allegations. It is determination of facts, which should at this stage be at least supported to determine whether there is sufficient or probable cause. That will be further heard in the proper hearing by this committee. So it is only proper that the recital of facts should at this stage be at least supported by evidence for us to declare that the complaint is sufficient not only in form but also in substance. Thank you, Madam Chairman.
Thank you.
Madam Chair.
The Honorable De Lima, and then Honorable Co, and then Honorable Tino, and then Honorable Garbin. Okay, one after the other. And then Honorable Rodriguez. The Honorable De Lima is recognized.
Thank you, Madam Chair. Good morning, everyone. Technically and strictly, and if we go by the standard set the House rules itself, the rules of procedure in impeachment proceedings, it's supposed to be just, we just have to look at whether the complaint has a recital of facts constituting the impeachable offense charged and determinative of the jurisdiction of this committee. I don't think there's any issue on the jurisdiction. This committee has jurisdiction. Now, the recital of facts constitutive of impeachable offense charge, in addition to what has been articulated earlier by the Honorable Chairperson about, it must not be based on conclusions. I would wish to further elaborate on exactly what sufficiency in substance mean. When we talk about substance, it refers to whether the complaint alleges ultimate facts that, if hypothetically admitted, would constitute an impeachable offense. So hypothetical admission lang. Hindi pa natin titingnan kung totoo o hindi o may supporting evidence ang isang allegation of fact. And as I said, in addition to the standards set in our own rules of impeachment, rules in impeachment proceedings, a complaint is sufficient in substance when it, number one, narrates specific acts or omissions, not mere conclusions. Number two, it shows a nexus, a connection between the acts complained of and an impeachable ground. Kailangan konektado yung mga allegations of facts doon sa constitutional ground. Number three, should be intelligible and coherent, allowing the respondent to meaningfully answer. Number four, it's not purely speculative or opinion-based. And then, pwede rin, in terms of just checking the sufficiency of the entire complaint, whether we can also look into whether it's supported by annexes or references, although proof need not yet be conclusive. Dahil nga po, evidence is not weighed at this stage. The test is allegational sufficiency, not credibility or truth. Yun po ang aking position. Thank you very much.
Thank you, Honorable De Lima. Now we recognize the Honorable Co.
Thank you, Madam Chair. Good morning to the committee. Once again, I also submit and I agree with the manifestation made by Representative De Lima. And I would just like to add further in regard to the discussion on ultimate facts. Given that actually the rules of court supportorily applies to the rules on impeachment under Section 19, I'd like to read Rule 8 of the Rules of Court of the Philippines, wherein it says that pleadings are required to set forth ultimate facts on which the party relies for a claim or defense. And as stated earlier, the ultimate facts are generally what is the allegation of the offense, the acts or omissions, and how it relates to the offense charge. That's different from evidentiary facts, which is not required to be included in a pleading yet, and that can come later on when we enter the hearing proper. And it's different also from conclusions of law. So right now, what is on the floor is the determination whether the ultimate facts are alleged in the pleading. And so given that we're at this stage right now, we will determine whether the complaints are sufficient in substance as to whether ultimate facts alleging the offense charged is sufficient for this body. That's all. Thank you.
For the guidance of all the members, our parliamentary status, we are determining whether or not the question of personal knowledge and authentic records, specifically with respect to the attachments, should be considered in the determination of sufficiency in substance. Moving forward, we now recognize the Honorable Tino.
Thank you, Madam Chair. The Honorable De Lima and Co, they have eloquently made the point that at this stage, this committee is not supposed to determine facts. This is not the proper stage for that. That will involve the hearing proper. No, so at this point, the complaints may be determined as sufficient in substance if they are found to allege facts that constitute a ground for impeachment. Hanggang dun lang po. Hindi pa po natin papasukin kung totoo ba talaga o hindi yung mga allegations sa complaint. Yun lang po, Madam Chair. And as to the question of authentic records and so on, my position there is that dapat tinanong yun kahapon. Dahil yun yung precisely, yun yung inaalam, no? Whether or not the verification requirement was satisfied. At ang sinasabi dun sa verification that the complaint is based on personal knowledge and or authentic records. And that has already been settled by the committee. Thank you, Madam Chair.
Thank you, Honorable Tino. Now we recognize the Honorable Garbin.
Thank you, Madam Chair. We are all guided here by the rules of impeachment of this House, and the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. The complaint before us, filed against the President, alleging impeachable offenses, namely culpable violation of the Constitution. Major allegations by category is the surrender of former President Rodrigo Roa Duterte to the ICC. It is noteworthy to mention, Madam Chair, and to this honorable committee, that the case before the Supreme Court questioning the constitutionality of the said alleged surrender and kidnapping, case of GR number 278762 in the matter of the petition for the writ of habeas corpus of Rodrigo Roa Duterte is still pending. In fact, the status of the case right now is that parties were required to file position papers. And so, therefore, Madam Chair, to my mind, these are mere conclusions, not established facts, Madam Chair. And later, I will manifest my findings on the major allegations such as the culpable violation of the Constitution, and will declare my vote and explanation to my vote, Madam Chair. Thank you.
While the opinion of the Honorable Garbin on the first offense is significant, we will be holding our discussion on the first offense until we thresh out the question on whether or not we will consider the attachment if they are authentic record for the purpose of determining sufficiency in substance. That is our parliamentary state right now. The Honorable Rodriguez.
Madam Chair, after hearing the discussions, I am fully satisfied.
So before we proceed to our discussion on the offense, that is kidnapping, we wish to thank the significant views and opinions as to the question of whether or not the attachments should be considered for the purpose of determining sufficiency in substance, no? And I understand that there are varying opinions. Some members would say or said that they should not be considered and we should stick on what are stated in the impeachment complaints, while some would say that they are necessary for the purpose of determining the substance or the sufficiency in substance. The chair wishes to elicit a motion as to whether or not we will include the attachment if they are authentic records for the purpose of determining sufficiency in substance as a preliminary matter.
Madam Chair.
The Honorable Ko.
Okay. Madam Chair, I move that for this portion of the discussion, the body contemplates whether the facts alleged in the complaints constitute the offense charged. And at this stage, we do not need yet to cross-check or check it whether it is supported by the evidence, be it based on personal knowledge or authentic records. I so move, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
point of order.
The Honorable Rodriguez is
The
recognized.
Honorable Ko is a party of the case as the endorser also in these particular proceedings. And so therefore, we will request all the endorsers that in the deliberation of the committee, they cannot participate. This is a proceeding akin to a preliminary investigation. And so the complainant and their lawyers would not be the one moving to the prosecution to proceed with the case. And so therefore, with due respect, let us allow our members, and of course, we will appreciate you at the proper time in the discussions to elaborate further the complaints. But as already parties, the party is the De Jesus complaint, Attorney De Jesus, and Jet Nisay, the endorser. Masa, the three respected gentlemen and lady. And so, the other party is the President Ferdinand Bombo Marcos. And we are the committee investigating. So therefore, let us wait for another member to move whatever is the motion about. So I would like to seek the ruling of the chair.
Would you like to comment to that, Honorable Ko, before we rule?
Okay. Thank you, Madam Chair, Honorable Rodriguez. While I understand the logic of the manifestation, we'd just like to manifest that the three complainants of the second impeachment complaint are members of the Committee on Justice. So again, we also respectfully seek the ruling of the chair in regards to this matter, whether or not we can participate in the deliberations of the discussion on the first impeachment complaint, because as at least provided by the rules, it is a right that is provided upon the members of the Committee on Justice. Thank you, Madam Chair.
The chair recognizes the right of each member of this committee, notwithstanding his dual capacity of being an endorser as well. So, in resolution of the question as to the capacity of the Honorable Court to raise a motion, the chair rules in favor of the authority and right of the member, notwithstanding the fact that she is an endorser as well, to raise the necessary motion.
But Madam Chair,
Before that, Madam Chair, we respect that ruling. Would therefore, in the voting of these two complaints, will Representative Ko be voting?
to the honorable members of this committee, we are exercising a very important process, and it is not the intention of this committee to impair whatever right and authority each of the member has in this committee. So if we are upholding the right of a member who is at the same time an endorser to raise a motion, we are likewise upholding her right to vote on the motion. Honorable Ko?
Madam Chair, before I answer, perhaps in the order also of the matters, given that we'd like to thank the Madam Chair on the ruling, but in deference on the discussions, I'd like to retract my motion and would allow the body to make that motion, given that there's this question. But nonetheless, we, as a member and in deference to the ruling of the chair, we will continue to participate in the discussions.
The chair has ruled already.
Okay.
The motion by the Honorable Ko is
Sustained.
upheld by the chair.
Okay.
So I will just be requesting for the rephrasing of the motion because it should not entail the evidence aspect of the attachment. The question only is whether or not the attachments as authentic records should be considered for the purpose of determination of sufficiency in substance. We are not yet on evidence. The Honorable De Lima is recognized.
Given the withdrawal by the Honorable Rene Co of her earlier motion, may I therefore make this motion? I move to exclude in the consideration of sufficiency in substance the determination of the authenticity of authentic records, if any, as attached to the complaint.
There
Do not
is-
consider.
There is a motion to exclude the authenticity of the attachments for the purpose of the determination of sufficiency in substance. Do I hear a second? Is there any objection?
I object, Madam Chair.
The motion has been objected to. We shall now divide the House. Those who are in favor of the motion, please raise your right hand. For the guidance of everyone, the motion is to exclude the authentic record constituting of the attachment for the purpose of the determination of sufficiency in substance. Those who are in favor of the exclusion of the attachment, please raise your right hand. You may put down your hands.
Madam Chair.
Let the chair restate the motion. The motion is to exclude the issue of authenticity of attachments for the purpose of determination of sufficiency in substance. In other words, whether we exclude or not. So if you vote in favor, we exclude the issue of authenticity of attachments. If you don't vote in favor, then we discuss on the issue of authenticity of attachments.
Chair,
The Honorable Tino.
may I clarify that the exclusion of the determination of authenticity is only for this stage, no? Because the position is
Of
that
course.
that should properly be done in the proceedings proper.
Correct.
Not at the stage of determination of sufficiency in substance. Para malinaw lang po, kasi baka isipin na yung motion ay ayaw na ma-determine kung authentic ba yung records o hindi. Ang sinasabi lang po, hindi po ito ang tamang panahon para
Correct.
gawin yun.
Okay.
May I be recognized, Madam Chair?
The Honorable SDML is recognized.
Just for purposes of determination of sufficiency of substance, I vote not to exclude. I vote to include.
That's
Kasi baka merong mga impeachment complaint na wala naman palang attachment o hawsyaw ang mga attachment. I am not saying na we will discuss the contents of the attachment. That would be for the proper hearing after we determine the substance. Ang sinasabi ko lang, dapat kapag may recital of facts, ang naka-attach dito ay mga dokumento na may probative value naman for proper hearing para hindi hawsyaw o haka-haka lang ang recital of facts. I submit, Madam Chair.
Madam Chair.
The Honorable Keith Flores.
Madam Chair, at this point, Madam Chair, I think it's enough that we rely on the verification under oath by the complainants themselves that it is based on true and correct facts and that it is also based on authentic records. Under oath, Madam Chair.
Madam Chair.
The Honorable Redon.
To be very clear po, I am only pertaining to the first impeachment complaint, and it's actually it's just a factual question. Which of the attachments are in fact certified through copies, no? Gusto lang ho namin malaman. We are not conflating this question on whether or not this proceeding should in fact even proceed. Kasi sa totoo lang, kahapon po, I was raising it already in the determination of form na in fact, in previous impeachment proceedings, an impeachment was denied, rejected by the committee on the basis of the absence of personal knowledge and authentic records on the question of sufficiency in form. So ibig ko sabihin, if we will not be allowed to determine this at this point, kailan po natin yun madedetermine, hindi ba? So yun lang ho actually, and it's not even my question. My question is basically just factual. Doon po sa first impeachment complaint, alin po doon sa attachment, yung sa totoo lang, certified true copy, at alin po doon sa mga yon, yung hindi, without conflating it onto whether or not this complaint should proceed.
Madam Chair,
Honorable Rodriguez.
like, we are not yet there. We are still, the requirement really is just recital of facts, ultimate facts. In fact, the annexes are really would pertain to what is stated in the complaint. That is why it's annexed. We cannot go to the annex now because we are only, according to the rules, only focus on the recital of facts constituting the offense, and the complainant should be able to put in that complaint, in the recital of facts, what are the basis why the respondent will be liable under the 6 grounds provided by the Constitution. And that is why we don't yet go to the annexes. They are already mentioned in the complaint, because otherwise the annex standing alone cannot stand. It is to enforce a statement of fact in the complaint. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. For the guidance of all the members, we've heard a lot of varying opinions. Some are in favor of excluding the attachments for the purpose of determination of sufficiency in substance. Some are not in favor. But for the guidance of everyone, before we proceed to voting, we are requesting the Honorable De Lima to restate the motion.
Thank you, Madam Chair. I move to exclude the determination of the authenticity of the annexes, the records as attached to the complaint, at this stage of the proceedings, which is the determination of sufficiency in substance.
All right, the same has been seconded, and the same motion was objected to by the Honorable Redon, and that is now, we are now dividing the House. Those who are in favor of the motion is to exclude. Raise your right hand. You may put down your hands. Those who are against the motion, please raise your right hand. You may put down your hands. Those who abstain, please raise your right hand.
Madam Chair, can I just say my,
Please wait, Vice Chair Dumogan, until we resolve the motion. Can we have the number of votes? Let me reconfirm. I find the numbers a bit doubtful. Okay. The motion, again, is to exclude the determination of authenticity of attachment for the purpose of determining sufficiency in substance. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. With 21 in favor of the motion and 24 against the motion, the chair declares not to exclude the authenticity of the attachment in the determination of sufficiency in substance. So ruled.
Madam Chair? Madam
Thank you.
Chair?
Madam Chair,
Madam Chair?
Can I call first Vice Chair Dumogan?
thank
Vice
you.
Chair Dumogan and then Honorable Tino. You're
Very
recognized.
short. Thank you, Madam Chair. I'm happy that we voted against the motion because if we voted in favor of that motion, it will be violative of Section 3. The Section 3 requires, based on authentic records, in all of a sudden, in the determination of sufficiency in substance, you will waive the determination of authenticity of document. It's violative of Section 3.
Thank you,
Madam
Vice Chair Dumogan. The Honorable Tino?
Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Madam Chair, in view of the fact that the chair herself had to call for a vote 3 times, and in the second instance, she even commented on the record na hindi siya makapaliwala sa resulta. Okay? So in other words, medyo wala pong clarity dun sa naging botohan, I move for nominal voting on the point, Madam Chair.
The Honorable Flores is recognized.
Madam Chair, Congressman Tino, I saw the numbers admitted by the Secretariat. We lost on both counts, sir.
Let us be reminded that this is just a preliminary matter, no? I hope we will be recognizing the decision of the majority of the committee in as far as this issue is concerned.
Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Madam Chair, with due respect to the members of the committee, it is this representation's belief that hindi po actually dapat subject to ng vote because the rule provided in the rules on impeachment proceedings that in this stage, to determine the sufficiency in substance, ang kailangan pong gawin is to determine whether there's a recital of facts constituting the offense charged. That's it.
With all due
hindi po
respect,
ito
the
nakalagay
Honorable Ko,
otherwise.
the committee has ruled already. The Honorable Garbin.
Thank you, Madam Chair. I've been hearing the position of the movant, and they invoke the rules of court as in suppletory character. Now, while impeachment is a political process, the determination in sufficiency in substance is analogous to a judicial requirement that a pleading must allege ultimate facts constituting a cause of action, not mere conclusions of law or argumentative narratives. Under Rule 8, Section 1 of the Rules of Court, pleading must state the material facts relied upon and not evidence on general averments of wrongdoing. Applying this standard, Madam Chair, by analogy, the first complaint largely asserts labels and conclusions, such as the betrayal of public trust. And therefore, it is but right that the majority of the members should assert to include and determine the authenticity of the attachment in the said complaint. Thank you, Madam Chair.
The Honorable De Lima.
Just a short comment, Madam Chair.
You're recognized.
Given the vote to still include the determination of the authenticity of supporting documents or authentic records, I believe it will unnecessarily delay the proceedings and prejudice the causes of any complainant. And it went outside the very essence of what is the determination or what is sufficiency in substance as explicitly laid down in our own rules. Tatagal po ang proceedings at unfair sa mga complainants and labag dun sa ating rules natin. Recital of facts constituting the offense charged. So what is the point of looking into or inquiring into the authenticity of supporting documents? That's my view, Madam Chair.
Thank you.
very
The
much.
Honorable Flores.
Madam Chair, I agree with Congresswoman De Lima. And I have also seen the complaint and the attachments for the impeachment complaint against the Vice President. And it's voluminous, Madam Chair. And if we follow that rule on that impeachment complaint, it will take us forever.
Madam Chair,
The Honorable De Lima.
thank you very much, Madam Chair. In view of these views expressed post-voting, may I move for reconsideration of the decision of the majority?
For the guidance of all the members, the question of the committee right now is only with respect to whether or not the records are authentic. It doesn't go into the truthfulness of the contents of the attachments yet, which is evidentiary already, no? The motion which we voted upon only pertains to whether or not we will include the issue of authenticity of the attachments. And I think that will be answered by merely checking on whether they are certified or otherwise. We are not looking into the truthfulness of the contents of the attachments yet, because we all agree that that will happen during the hearing proper of this proceeding. So with the indulgence of all the members, we have voted upon this motion. This is merely preliminary. We have 5 grounds to discuss, 5 offenses anchored on 3 grounds to discuss. We shall now proceed to hear the comments and manifestation on the first ground. That is kidnapping and surrender of the former president constituting either culpable violation of the Constitution or betrayal of public trust.
Madam Chair. Yeah.
Is this about the first
It's
offense?
still about the annexes, Madam Chair.
We have ruled on that issue already. So
Madam Chair, let's
in the
proceed.
interest of
Let's
time,
proceed.
in the interest of time and with the indulgence of all the members, let us proceed to hear the comments and manifestations on the offenses and whether the same constitute a ground for impeachment.
All right, I just wanted to state for the record, Madam Chair, that proceeding to the first ground,
The first offense.
the first offense, most of the annexes are news articles. I'm stating it for the record. They're only, for the entire complaint, there are only, I think, 3 annexes that are official records on which I'm asking on whether or not there exists a certified true copy for it when it was submitted to the House. No? So this is Annex U, transcript of Committee on Accountability of Public Officers and Investigations, Blue Ribbon, 25 September 2025. Annex L, Supreme Court decision dated 3 December 2025, Pimentel versus House of Representatives. And Annex A, Committee Report, Committee on Foreign Relations. Everything else, Madam Chair, are actually news articles that had been submitted as attachments to this particular complaint. And I think there is particular relevancy to it because I'm quite certain that it might be insufficient for evidence to be based on mere news articles only. So going to the allegation relating to kidnapping and arresting the president and bringing him to The Hague, I think it needs to be stated, Madam Chair, that the arrest of the former president is in pursuance of a treaty obligation between the Republic of the Philippines and Interpol. So, wala pong batayan para sabihin that the former president was kidnapped. More importantly, kidnapping is a legal conclusion and it does not constitute as a statement of fact. No? So, doon pa lang po, parang meron na pong problema yung pong ground po na ito. So, to be clear, ang annex po on the matter is Annex A, Committee Report, Committee on Foreign Relations. Annex B, Senate probe reveals lapses in Duterte's arrest. Daily Tribune, 27 March 2025. Annex C, Duterte ICC arrest. Inquirer, 27 March 2025. At Annex D, VP Sara on father's arrest. GMA News Online, 20 July 2025. But I think it has already been sufficiently established, Madam Chair, that this was not a kidnapping. This was an implementation of a warrant that had been issued by the Interpol, in which Interpol sought the assistance of the Republic of the Philippines to implement this particular arrest warrant against the former president. To be clear, this is not in pursuance of a relations between the International Criminal Court and the Philippines, because this relation has already been broken when we had left the ICC in the previous government. So, para malinaw lang po, walang batayan para sabihin na meron pong pananagutan ang ehekutibo dito po sa pag-aresto sa dating Pangulo at pagdadala po sa kanya sa International Criminal Court, Madam Chair.
Madam Chair.
The committee notes the manifestation of the Honorable Ridon. The Honorable Chua is recognized.
Thank you, Madam Chair. Madam Chair, I share the observation of the Honorable Terry Ridon, and I also submit that there is insufficiency in substance for a very simple reason that we all should be guided by the elements of the crime alleged, which is kidnapping. Ano po ba para pumasok sa kidnapping? Maliwanag naman po sa ating revised penal code. Number 1, kailangan yung offender is a private individual. Dito pa lang po, wala na po, tapos na po yung usapin. Pangalawa, dapat po ay yung act, dapat po, the act is illegal or the deprivation of liberty is without legal justification. Maliwanag naman po that the arrest of the former president was via warrant issued by the International Criminal Court. So dito pa lamang po sa dalawang elementong ito ng kidnapping, wala na po, kulang na po. Kaya masasabi ko po na yung offense charge will not be sufficient in substance. Thank you po, Madam Chair.
Madam Chair, may I
Thank
be
you.
recognized? Madam Chair.
The Honorable Po, and then Honorable Chel Jokno, and then Honorable De Lima. And then Honorable Vice Chair Dumogan.
Madam Chair, thank you for recognizing me. Just for clarity, would it be possible to ask the endorsers if they're aware of any kidnapping cases that were filed against any members of the administration in relation to the ICC arrest?
May we request the endorser, the Honorable Nisay, to answer the question of the Honorable Po?
Madam Chair, sagutin ko lang yung kabuuan. Attached sa DSUS complaints ang ilang dokumento o public records at pati na rin sa mga news articles kasi sila ang pinaka-accessible.
If I may interrupt, Honorable Nisay, the question is very specific. Whether or not you are aware of a case of kidnapping filed against the impeachable official.
Am I aware, Madam Chair?
You are?
Aware.
So you are aware that there is a case of kidnapping filed against the impeachable official?
No. That there is no, ma'am.
Okay. So does that satisfy your question, Honorable Po?
Yes, Madam Chair. The reason why I asked that is because in order for us to determine that kidnapping had taken place to begin with, if there was kidnapping, shouldn't there have been a case filed against any administration official involved in the ICI arrest?
You mean not only the impeachable official?
Not only the impeachable official, because even if
Madam
we're saying
President,
responsibility-wise,
Madam Chair, the President
shouldn't the
is
case have
immune
been
from
filed?
suit, and therefore
That
there's
is
no
correct.
case pending before this President.
All right.
But Madam Chair, even if the President is immune from suit, no other official in the administration has a case pending regarding kidnapping.
Okay.
Am I
To
correct?
complete the question of the Honorable Po, he's asking if you're aware of any case filed against any government official in relation to the alleged kidnapping and arrest of the former president. Honorable Nisay?
Yes, Madam Chair, I am aware that no pending case.
He is aware that no cases were filed against any government official.
That's all, Madam Chair. Just wanted to establish that for the decision-making of those who will be determining substance on the grounds of kidnapping.
Thank you, Honorable Po. Honorable Jokno is recognized.
Thank you, Madam Chair. First, a point of clarification on the ruling of the chair and of the committee. Does this mean that during the next phase or the evidentiary phase of these proceedings, the complainants will not be able or will not be given the opportunity to authenticate their documents? Because I believe that that is a part of due process that should be accorded during the evidentiary phase. I am concerned because this ruling will have an effect on other impeachment complaints, that if we adhere to this and strictly apply it, that would we would be depriving complainants of their day in court. I'm very concerned about this, Madam Chair, because as I understand it, we go first through the form, which is a very simple process. We then look at the complaint in terms of sufficiency and substance, which, as Congresswoman De Lima said, is simply looking at the allegations of the complaint and hypothetically admitting that they're true. And then, only after that, do we look at the evidence and allow the parties to authenticate their documents. I don't think there's any requirement at all in our rules that require that all documents upon filing of the complaint already be duly authenticated.
The Honorable Vice Chair Dumogan.
Let us read Section 3 of our own rules. Second paragraph. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. There we are. The rules of the impeachment of the House requires that those documents to be attached must be based on authentic records. That's what I was pinpointing.
Madam Chair.
I might somewhat agree with you, but that is our own rules.
May I respond, Madam Chair? The way I understand it, that matter should have been taken up when we discussed the form in terms of whether the verification was proper or not. We have already gone past that stage. We are now looking at the sufficiency and substance of the complaint. And later, assuming it is sufficient in substance, I think we have to give the complainants the opportunity to substantiate, authenticate their submitted documents.
Madam Chair,
The Honorable Tino.
in addition to that, I would point out that the requirement in the determination of sufficiency in substance, where it says that the complaint must be a verified complaint, meaning to say it is based on personal knowledge and or authentic records, that requirement is satisfied through the submission of a verification duly sworn to and notarized. So for purposes of these preliminary stages of the impeachment proceeding, for as long as there is a verification duly notarized, then that requirement that this is a verified complaint has already been satisfied. Lagpas na po tayo doon.
With the
Madam Chair.
indulgence of the members of the committee, let us all be reminded that we've ruled already on the issue of the inclusion or exclusion of the issue of the authenticity of the attachments. As to the question of the Honorable Jokno, whether we will be allowing its authenticity during the reception of evidence, we reserve the discussion of that issue as we reach that matter, which is the reception of evidence during the hearing proper. We are reminding the members of the committee to confine the discussions and manifestations to the offense which is being discussed at the moment. We are on the first offense. The Honorable Padiernos.
Madam Chair, may I proceed to propound some clarifications and questions?
Is it on the first offense?
Yes, Madam Chair.
You may proceed.
I would like to address the questions to the Honorable Nisay. So, for clarity, the grounds for the first allegation is based on culpable violation of the Constitution and betrayal of public trust. Is that correct, Madam Chair?
The Honorable Nisay?
Yes, Madam Chair.
Madam Chair, may we know from the endorser which specific, in terms of the culpable violation of the Constitution, which specific provision in the Constitution did in this case, the President violate?
Representative Nisay may answer. The question is the specific provision of the Constitution which was violated by the impeachable official.
Yes, Madam Chair.
Madam Chair, can request 2 minutes break.
Of course. Let us be reminded by our understanding about the sufficiency in substance that the offense alleged we should be able to connect the offense alleged to the ground of impeachment under which the same is anchored. And I wish to believe that this is the rationale behind the question of the Honorable Padiernos, why he is asking what specific provision of the Constitution was actually violated in relation to allegation of the kidnapping and arrest of the former president. Would you like to move to your next question or manifestation while the endorser thinks over the proper answer to your question?
Madam Chair, this is very important because according to the rules of the House on impeachment, in determining the sufficiency and substance, we must determine whether there's a recital of facts constituting the offense charge. So this is very important to know which exact provision of the Constitution did the impeachable official violate.
So, Madam Chair,
You recognize Honorable Nisay?
under po the due process, nirerespeto po natin yung Constitution.
It is the due process clause.
In that sense, Madam Chair, would well, may we know from the endorser that whether any Philippine court has issued a finding that there was a violation of due process or that the arrest constituted kidnapping?
Madam Chair, none so far.
So in this case, Madam Chair, it would appear that on the basis of the first ground, there is no impeachable offense. And to add on to that, Madam Chair, may we know from the endorser whether there is an actual written presidential order with regard to the arrest of the former president.
Madam Chair, wala po pero under the directive po yung ng presidente, ang PNP.
Congressman Padiernos, he's saying that the PNP was under the directive of the impeachable official, that's why. Notwithstanding lack of order coming from the president.
But again, Madam Chair, we are determining here there must be an overt act personally attributable to the president or the impeachable official. So how can we say that the impeachable official it should be liable because of the supposed action of the PNP in this case?
Honorable Nisay, Honorable Padiernos is asking for the overt act committed by the President or the actual participation with regards to the alleged arrest and kidnapping.
Madam Chair, I think yung dapak po na wala siyang ginawa. Yun po yung
So, Madam Chair, is omission equivalent to an impeachable offense?
Madam Chair, for us po, isa yes.
I rest my case, Madam Chair. I would just like to manifest that based on the answers propounded by the endorser, and with due respect, this representation does not believe that on the first ground that there is an action, there is a recital of facts that would constitute the offense charge being culpable violation of the Constitution and betrayal of public trust. That's all,
The
Madam Chair.
committee notes the manifestation and answer of the endorser. The Honorable Suntay.
Thank you, Madam Chair. Through you, Madam Chair, on the first ground, alleged culpable violation of the Constitution, the complainant alleges that the President ordered or enabled the arrest of and surrender of the former President Rodrigo Duterte to the ICC, did so without a valid Philippine warrant, therefore violating national sovereignty, due process, and constitutional guarantees. Would that be correct?
Yes, Madam Chair.
So the legal theory asserted, Madam Chair, is that the ICC surrender constitute a constitutional violation and therefore an act of betrayal of public trust. Would that be correct?
Yes,
Honorable
Madam
Nisay.
Chair.
And may I know, Madam Chair, through you, may I know what would be the evidence to support these allegations? I was reading the complaint. I saw Senate committee reports, media articles, statement of public officials, and it was limited to that. Would there be any other?
Madam Chair, yung mga news articles, yung mga publicly available published articles. Kasi sila po yung pinaka-accessible na form ng public record na nag-reflect ng mga event, timelines at statements na alam naman ng public. Gaya po ng sinabi ko kanina, isa sa mga layunin ng mga news articles na ito ay mag-establish ng pattern na mayroong nangyayaring graft and corruption, culpable violation of the Constitution, betrayal of public trust. Kumbaga sila ay mga circumstantial evidence na pag nag-combine ay magpo-form sa conclusion na karapat-dapat nang i-impeach ang ating presidente dahil siya ay karapat-dapat hindi mamuno.